A company can appoint a person as a director even when the shareholders have not yet appointed that person in the general meeting. But there is a catch. Can the board appoint anyone as an additional director? Can an alternate director continue forever? Can an existing director become an alternate director? And who actually controls a nominee director? These questions look simple, but Section 161 has several conditions hidden inside its subsections and provisos. In this Masterclass Lecture 22, we are going to understand Section 161 in complete detail. We will cover Additional Director under subsection 1, Alternate Director under subsection 2, every proviso under subsection 2, Nominee Director under subsection 3, Casual Vacancy under subsection 4, the 2017 amendments, IFSC company modifications, Independent Director conditions, Board authority, Articles of Association, General Meeting authorization, Rules and related compliance, DIR 12, DIR 2, DIR 8, DIR 3, practical examples. And finally, I will give you an exam-style question where one small fact can completely change the answer. Let us start with Section 161, subsection 1, Additional Director. Section 161, subsection 1 says that the articles of a company may confer power on the board to appoint any person as an additional director. But there is one very important restriction. A person who failed to get appointed as a director in a general meeting cannot be appointed as an additional director. This is a very important exam point. Suppose Mr. A is proposed as a director in the general meeting. The shareholders vote against his appointment. Can the board immediately appoint Mr. A as an additional director? No. Section 161, subsection 1 specifically prevents this. The board cannot use the additional director route to bypass the decision of the shareholders. Now, another important condition. The power to appoint an additional director must be available in the Articles of Association. If the articles do not confer this power, the board cannot simply assume that power. Therefore, before putting an additional director appointment before the board, the first compliance check should be the articles. Now, how long does an additional director remain in office? The additional director holds office up to the date of the next annual general meeting, or the last date on which the annual general meeting should have been held, whichever is earlier. This phrase, whichever is earlier, is extremely important. Let us understand with an example. Suppose an additional director is appointed on January 1st. The company holds its next AGM on September 30th. The additional director holds office up to the AGM on September 30th. Now change the example. Suppose the AGM should have been held on the 30th of September, but the company does not hold the AGM. The additional director does not continue indefinitely. His office ends on the last date on which the AGM should have been held. Therefore, remember, additional director is a temporary board appointment. It is not a permanent appointment. Now let us move to Section 161, subsection 2, Alternate Director. This is one of the most interesting provisions of Section 161. The board may appoint an alternate director if it is authorized by the articles, or if the company has passed a resolution in general meeting authorizing the board. So the authority can come from two sources: articles or general meeting resolution. The board then exercises the power. Now comes the most important condition. The original director must be absent from India for a period of not less than 3 months. Therefore, absence of 1 month is not sufficient. Absence of 2 months is not sufficient. The statutory threshold is not less than 3 months. Now, there is another important restriction. The person appointed as alternate director cannot be a person holding any alternate directorship for another director in the same company. And the provision also restricts a person who is already holding directorship in the same company. The purpose is to avoid confusion in board composition, quorum voting, and dual capacity. Now comes the first proviso. Can an alternate director be appointed for an independent director? Yes, under the Companies Act, only if the proposed alternate director is qualified to be appointed as an independent director under the Act. That means the person must satisfy the applicable independent director requirements. But there is an additional important point for listed entities. For listed entities, SEBI regulations impose an additional restriction relating to appointment of an alternate director for an independent director. Therefore, in practical compliance for a listed company, do not stop at Section 161. Section 149 applicable SEBILODR provisions. And the current regulatory framework must also be checked. Now comes the second proviso. How long can an alternate director continue? The alternate director cannot hold office for a period longer than the period permissible to the original director. And there is an automatic exit trigger when the original director returns to India. The alternate director has to vacate office. This means the alternate director does not become an independent permanent director. His position is linked to the original director. Now consider this example. Director A goes outside India for 5 months. Director B is appointed as alternate director. After 2 months, Director A returns to India. Can Director B continue as alternate director because the original 5-month period has not expired? No. The return of the original director triggers vacation of the alternate director position. Now comes the third proviso. Suppose the original director's term ends before he returns to India. What happens to the alternate director? The provision regarding automatic reappointment of retiring directors applies to the original director, not to the alternate director. This is another important exam point. The alternate director does not automatically inherit the original director's right of reappointment. Now let us look at the authority question. Who appoints the alternate director? Not the original director, not the managing director individually, not the company secretary. The board appoints the alternate director, but the board must have the necessary authority through the articles or a general meeting resolution. This distinction is very important. Now let us move to Section 161, subsection 3. Nominee Director. Subject to the articles, the board may appoint a person as a director nominated by an institution. The nomination must arise pursuant to applicable law or an agreement, or nomination by the central government or state government by virtue of its shareholding in a government company. So the concept is different from an additional director. Additional director. The board identifies and appoints a person under the authority contained in the articles. Nominee Director. The appointment originates from a nomination right available under law or agreement or specified government shareholding. Let us understand this with a practical example. Suppose a financial institution provides funding to a company. Under the financing agreement, the institution has the right to nominate a director. The institution nominates Mr. X. Subject to the articles and applicable law, the board can appoint Mr. X as a nominee director. The important point is that the nomination right must have a legal or contractual foundation. It cannot simply be an informal request. Now let us discuss section 161, subsection 4. This provision deals with casual vacancy. If the office of a director appointed by the company in general meeting becomes vacant before the expiry of his term, the resulting casual vacancy may be filled by the board. But there are conditions. The appointment is subject to the articles. The board must act at a board meeting, and the appointment must subsequently be approved by members at the immediate next general meeting. This is an important distinction from additional director. Additional director is appointed under subsection 1. Casual vacancy is dealt with under subsection 4. Now, how long will the person appointed against the casual vacancy continue? Only up to the date up to which the original director would have held office if the vacancy had not occurred. So again, the replacement does not receive a fresh independent term. The replacement completes the remaining tenure of the original director. Let us take an example. Director A was appointed at the AGM for a term ending in September 2028. Director A resigns in March 2027. A casual vacancy arises. The board appoints Director B. Director B does not receive a new term of 5 years merely because he was appointed in March 2027. He holds office only up to the date up to which Director A would have held office. Subject to the statutory requirements and member approval, now an important amendment history. Section 161 has undergone changes through the Companies Amendment Act 2017. Some changes became effective from 9th February 2018. One important change relates to the wording concerning the alternate director. The provision now specifically addresses a person holding directorship in the same company. Another important change relates to Section 161, subsection 4. The earlier wording contained the expression "in the case of a public company." The present provision, as reflected in the amended Act, continues to specifically deal with casual vacancy in a public company. Therefore, when you study Section 161, do not rely only on old notes or old question banks. Always check the amended statutory language. Now let us talk about IFSC company modifications. Specified IFSC public companies and specified IFSC private companies have specific modifications to Section 161, subsection 3. The modified provision allows the board to appoint a person nominated by an institution, company, or body corporate, in addition to the nomination sources available under the general provision. This modification arises from the specific regulatory framework applicable to specified IFSC companies. So once again, company category matters. Normal company, specified IFSC public company, specified IFSC private company. The applicable modification must be checked before applying the general provision. Now let us connect Section 161 with the company's appointment and qualification of directors rules. Section 161 itself primarily gives the substantive power of appointment. The procedural compliance does not end there. For appointment of a director, the company should also examine the applicable requirements relating to consent to act as director, director disqualification, DIN, interest disclosure, and ROC filing. For example, Form DIR2 is relevant for consent to act as director under the applicable rules. The company also has to check the disqualification requirements under Section 164 and the related rules. Form DIR8 is relevant to the required declaration regarding disqualification, and the appointment has to be appropriately reported to the registrar through the prescribed filing framework. In practical, company secretarial compliance DIR 12 is particularly important for reporting appointment and cessation of directors. Therefore, the Section 161 appointment should never be treated as only a board resolution exercise. It is a complete compliance process. Check articles, check eligibility, check DIN, obtain consent, obtain required declarations, pass the appropriate board resolution, make the required ROC filing, update statutory registers, and make the necessary disclosures. Now let us understand whether Section 161 appointment can be done through circulation. This is where you have to distinguish between different subsections. The statutory language of Section 161 does not impose the same board meeting requirement for every appointment under the section. For an alternate director under subsection 2, the board exercises the appointment power, and subject to the applicable provisions relating to board resolutions, the appointment may be considered through the appropriate board resolution mechanism. For a casual vacancy under subsection 4, the section specifically says the board fills the vacancy at a meeting of the board. Therefore, always read the exact wording of the relevant subsection. Do not apply one procedure automatically to every type of director appointment. Now let us understand 3 directors through one simple story. Company X wants additional management expertise. It appoints Mr. A as additional director. That is, Section 161, subsection 1. Director B goes outside India for more than 3 months. Company X appoints Mr. C to act in his place. That is, Section 161, subsection 2. A financial institution has a contractual nomination right and nominates Mr. D. The board appoints Mr. D as nominee director. That is, Section 161, subsection 3. Director E, who was appointed by shareholders, resigns before completion of his term. The board fills the resulting casual vacancy subject to the statutory requirements. That is, Section 161, subsection 4. Now notice the difference. Additional director, temporary appointment until the next AGM or the last date on which AGM should have been held. Alternate director, temporary replacement during the qualifying absence of the original director. Nominee director, appointment based on a nomination right under law or agreement or specified government shareholding. Casual vacancy, replacement for the remaining tenure of a director whose office becomes vacant before normal expiry. These 4 concepts should never be mixed. Now let us take a practical example. A company has an article authorizing appointment of additional directors. The board wants to appoint Mr. X as additional director, but Mr. X had earlier stood for appointment as director in a general meeting and failed to obtain the required votes. Can the board now appoint Mr. X as additional director? No. Section 161, subsection 1 specifically prevents the appointment of a person who failed to get appointed as director in a general meeting. Now another question. Director A is outside India for only 2 months. Can the board appoint an alternate director under Section 161, subsection 2 number? The statutory requirement is absence for a period of not less than 3 months from India. Now another question. Director A returns to India after an alternate director has been appointed. Can the alternate director continue until the next AGM? No. The alternate director has to vacate office when the original director returns to India. Now another question. A nominee director is nominated by an institution. Can the nominee automatically become a director without the board appointment? The answer is not simply yes. Section 161, subsection 3 gives the board the appointment power subject to the articles and the applicable nomination right. Now let us discuss one important compliance distinction. Appointment by board does not mean every board appointment is permanent. Section 161 contains temporary and special appointment mechanisms. That is why tenure must always be checked separately. Additional Director. Next AGM or last date for AGM, whichever is earlier. Alternate Director. Linked to Original Director. Nominee Director. Subject to the nomination framework. Casual Vacancy. Remaining tenure of Original Director. Now here is your masterclass question. A company has authorized the board through its articles to appoint an alternate director. Director A leaves India for 4 months. The board appoints Director B as alternate director. After 2 months, Director A returns to India. Director B says that he should continue until the next AGM because his appointment was approved by the board. Is Director B correct? Option 1. Yes, because board appointed him. Option 2. Yes, because 4 months was the original absence period. Option 3. No, because the alternate director must vacate when the original director returns to India. Option 4. No, but only if the shareholders pass a resolution. Think carefully. Read the second proviso to section 161 subsection 2. Comment the correct option and give the reason. And here is the second question. If a person failed to get appointed as a director in a general meeting, can the board appoint that same person as an additional director? Comment your answer. Now let us finish with the short recap. Section 161 deals with 4 important appointment situations: additional director, alternate director, nominee director, and casual vacancy. Additional director requires authority in the articles. A person who failed to get appointed as director in a general meeting cannot be appointed as additional director. Additional director holds office up to the next AGM or the last date on which AGM should have been held, whichever is earlier. Alternate director requires board authority through the articles or general meeting resolution. The original director must be absent from India for not less than 3 months. The proposed alternate director cannot fall within the statutory restrictions. An alternate director for an independent director must satisfy the applicable independent director requirements. The alternate director cannot continue beyond the permissible tenure of the original director. And when the original director returns to India, the alternate director vacates office. Nominee director is appointed based on nomination under law, agreement, or specified government shareholding. Casual vacancy is filled by the board in the circumstances covered by Section 161, subsection 4, and is subject to subsequent member approval at the immediate next general meeting. The replacement normally holds office only for the remaining tenure of the original director. Always check the articles. Always check eligibility. Always check Section 164. Always check the applicable rules. Always check the prescribed forms. Always check ROC filing requirements. And for listed entities, always check the applicable SEBI requirements as well. The biggest lesson from Section 161 is simple. Board appointment does not mean unlimited appointment power. Every category of director has a different legal trigger, a different tenure, a different condition, and a different compliance requirement. If you want to master Companies Act provisions section by section with amendments, rules, exceptions, practical examples, and board-level compliance, Subscribe to Corporate and Securities Law Compass. Navigating the law with clarity. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a Company Secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright Corporate and Securities Law Compass. Navigating law with clarity. All rights reserved.